We'll go on the record in the matter 24 CF 50, State of Wisconsin versus Adam Evans. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Evans appearing in person in custody with his counsel, Daniel Chapman. We're set here today in this matter for the sentencing part of this case. Mr. Evans pled guilty on March 13th to 1 count of driving or operating a vehicle without consent, a Class I felony, 1 count of burglary of a building or a dwelling as a party to a crime, a Class F felony, and 1 count of driving or operating a motor vehicle without consent, an I felony. The court ordered the pre-sentence investigation report. The court has received and reviewed the report. And I am not sure, but I think there was an error on page 11 as it relates to Mr. Evans' Polk County case 24 CF 40. I don't believe that's the correct case number.
Yeah, it must be 50.
I believe that was the only error that popped out to me when I reviewed, because I don't have as much intimate and personal information as either the state nor the defense. Mr. Schmidt, did you receive the pre-sentence investigation report?
I did. I reviewed it. I have no corrections.
Mr. Chapman?
I have it. I reviewed it with Mr. Evans. We have no corrections.
All right, thank you. And Mr. Evans, that's true. Mr. Chapman went over that with you?
Yes, ma'am.
And you could not find any material errors that needed to be corrected?
No, ma'am.
All right, thank you. We are in victims' rights compliance. We do not have any victims who are going to be making any statement today. So we'll proceed to arguments. Mr. Schmidt.
The state is going to be arguing something in the middle of the Department of Corrections recommendation. It's going to be arguing for 6 years initial confinement, followed by 4 years extended supervision, totaling a 10-year sentence on the burglary. For the other counts, the state's going to recommend following DOC's recommendation to run those concurrent, and they gave various ranges for that. This recommendation is primarily driven by need to protect the public, gravity of the offense, and rehabilitative needs of the offender. As to gravity of the offense, it's really high. As the owner said in his victim impact statement, he had gone through a long time where he had not been burglarized, and then he got hit twice within a short period of time. This was the second time. He's at a loss because he still hasn't recovered everything that was lost. The nature of the offense, especially in conjunction with the criminal history, means probation would unduly depreciate the seriousness of the offense, especially with the read-ins. The version of events that Adam Evans gave in the PSI, I believe, is correct. When we did the sentencings for the other co-defendants, Charles Evans and Chantel Bentley, I spent a long time outlining all the physical evidence, all the high-tech digital things we did, and explained how it showed that both of those people, when they gave their version of events in the PSI, gave things that were plainly contradicted by the physical evidence. And I argued that was evidence that those two individuals were denying responsibility for it. The account that Adam Evans gave is the account that law enforcement believes fits the evidence. Both Charles and Chantel denied responsibility for entering the black and orange and claimed they were sitting out in the vehicle. So all 3 people claim that, despite the fact that footprint evidence showed Charles did go in, and the 2 people who went in were tall, and Mr. Evans has a much broader frame than both of them, and he obviously was not the person in there. So to that extent, that's something that weighs in Evans' favor. He's owning up to what he did. He's actually telling the truth about what happened, and he is coming to the court and accepting responsibility in a way that the other 2 co-defendants did not. On the other side of the coin, the main aggravating factor in this case that bleeds into the gravity offense, the need to protect the public, and rehabilitative needs is the fact that he did this with his high school age son. There are numerous red flashing signs across a lot of the evidence, namely like the messages and whatnot, that Charles Evans loves his dad and wants to be like his dad and follows him in many ways, for better or for worse. Whatever Adam does, Charles will follow. We talk a lot in this courtroom about the awesome responsibility that parents have to guide their children. It's not just the things we tell them to do or do with them, but the model we set ourselves for them. Adam's youth in the PSI involved some early thievery, along with consistent substance abuse over a long period of time that crescendoed into that federal prison sentence for a drug conspiracy. That sentence robbed Charles of his father for many years. When Adam got out of prison, he starts doing this thievery type stuff with his son. He puts his son on the same path he took when he was Charles's age. And sure enough, while Charles is out on bond in his part of this case, he gets arrested for selling drugs. The same behavior that landed his father in prison, the same behavior that Adam describes his father, Roger Evans, having problems with. And now we have a chain of behavior stretching 3 generations of men in the Evans family, from Roger's Mexican cartel activities to Adam's federal drug conspiracy to Charles selling THC, the consistent trend of the thievery-related activities from Adam to Charles that he says is connected to the drug use, even though Adam says that his father, Roger, wasn't involved in thievery and said things like, "I don't like thievery," and that was part of his motivation for getting into it. I lay this all out here because this is why family stability, attitudes, and values is in the PSI, why it's a category. These are things that are predictive of the future should no intervention occur. It sure seems like Charles Evans is still influenceable by his father. His father took the skills that it's documented he learned in federal prison, and I suspect it's skills that also built into the employment he was able to procure as well, and applied that to his son, taught his son skills, or took his son on that path. His son would likely follow. The chain of generational crime could stop with Adam and Charles, and thus the community would be protected in the future from crime from either of them. The problem is that it sure looks like instead it was a different skill set that Adam imparted onto his son, or at least taught him for this offense. And that is problematic. Thus, there's a need for specific deterrence of Charles Evans, not just for the offense that he committed of the burglary, but who he did it with and who was obviously learning from him and Chantel Bentley. He always had the chance at a bare minimum to keep his son out of this lifestyle. You go beyond that, another problem we look at with Mr. Evans that I think is aggravating is his history and his adjustment on supervision. Adam Evans has not made significant gains while on probation. The probationary periods, when you look at the PSI, they've always known there's been an AOD issue and it's never been tackled. The gains they document him making in federal prison, however, have been extraordinary. He got a lot of specific training there. He got his HSED well in there. He did extremely well in a confined setting. Thus, there's good evidence that he succeeds best in a confined setting. And we know, since he says that the driving force of the burglary here was the substance abuse, and the read-in involves him being in a vehicle with Leanna DeMar's user who had a large amount of meth. We know that's a present issue. That's something he still grapples with. You never beat addiction. You only ever control it or deal with it. And right now he's not dealing with it and he needs treatment, and a confined setting is where we see he's done best at that. The duration of the prison sentence should be tailored towards the high end because of the criminal history and because of the aggravating fact that he's laying the path for his son to do the same behavior in the future. It harms the community and to a greater extent harms his son. Seeing a stiff sentence might be something that would specifically deter Charles Evans from continuing that path in addiction and in terms of doing the thievery style offenses, in addition to the general deterrence of the public. When we say general deterrence, there's 2 types of deterrence. There's general deterrence and there's specific deterrence. There's specifically deterring this offender, and then there's general deterrence of the public. We can actually see a real general deterrent effect here because we can pick a person out from the general public and see how a higher sentence here would be conveying a message to that person: don't follow that path. So there's a much higher general deterrent effect in this case than we normally see. The court should also incentivize Adam Evans to participate in programming in prison by making him eligible for CIP and SAP. Like I said, part of the reason why a confined sentence is appropriate for him is because he does well there. So he should be incentivized to do those. Just like the feds did. The feds incentivized him to make himself better, and he did. He did a lot of things to improve himself in federal prison. I think there's a lot of reason to believe that he might do so again in state prison. I just think the court should stagger it so that he can't get the benefits of the program initially. That is, it should set a period by which he's allowed to take advantage of the release portion of it. Not staggering it until he can't start it until a certain time, but the release portion, because we want him to start it as soon as possible. I would suggest something in the 3 to 4 year range of that, because there is a need for actual punishment in this case because of the gravity of the offense for the reasons I outlined before, and also for the general and specific deterrent effects. So to sum up, the defendant obviously has rehabilitative needs. There's a long documented history of AODA issues with Adam Evans. There's also a long documented history of thievery related things, because when you look at his early history, stealing that stuff. These concerns are best addressed in a confined setting because of the lack of success on supervision previously, and because there just is a need for punishment here as well. Furthermore, the history is aggravating because of the aforementioned pattern of stealing. Thus, there's a greater need for that specific deterrence for this offender. We can't do the same things over and over and expect different results. Additionally, the defendant bringing his son into his criminal enterprises and the trends we've seen from his son has been disconcerting. Adam Evans got a lot of skills in federal prison. He could very easily use those skills to be a good model for his son. Instead, he's imparted the bad skills that he knows to his son. That fact in particular lends towards general deterrence and lends towards a higher sentence. We need to deter both Charles Evans and we need to deter both Adam Evans and the general public, which includes Charles Evans. Thank you.
Thank you. Mr. Chapman? First off, before I ask for your argument and recommendation from you, is there a stipulation to the restitution of $13,840.95?
Mr. Evans would like a restitution hearing on that, Your Honor.
Okay. So
that was part of the offer that he stipulated to that, though.
That's stipulating to the amount?
Yeah, stipulate to restitution.
I thought that's why I wrote it down.
Do we have the plea questionnaire? Because I actually looked for that on this exact issue and couldn't find it.
I don't have it. We've looked, and it's not in the electronic file. Any ones that I would have kept up and accidentally not provided would be up here. And the only one I have is a Jeffrey Bloom. So why don't we'll just take a little bit of time. 5 minutes enough, or do you want 10?
5 is probably fine. Can I step out into the hallway with Mr. Evans?
No, you may not. We will all vacate except for the officer. As previously noted, the court allowed Mr. Evans to have a confidential conference with his client. The court also then permitted Mr. Evans to go up to over to his jail cell to look through his paperwork to see if he had that copy of the plea questionnaire waiver of rights form. He indicated he could not find a copy. Is that correct, Mr. Evans?
Yes, ma'am.
Okay, thank you for looking.
Yeah.
Okay, Mr. Chapman, as it relates to, I guess, that matter, that issue.
Your Honor, I could tell from my notes that in discussions over the plea resolution, I had just written down restitution, and it wasn't clear whether that was stipulates to the $13,000 or whatever is in the restitution request, which I believe I hadn't even received at that time, or whether it was we agree that he's joint and severally responsible for restitution. In any case, the remedy would not be that the court has to agree with us. The remedy would be if there's no meeting of the minds, the plea would be undone, and Mr. Evans does not want that. He is willing to stipulate to the amount requested by the state.
All right, thank you. So he is going to request or stipulate to $13,840.95, joint and severally liable with all co-defendants.
Yes.
All right. Okay, thank you. Now let's move on. Mr. Chapman, argument and sentencing recommendation, please.
Your Honor, I don't believe that the state and I are too far off in our requests. I agree that a prison sentence imposed at this time is an appropriate resolution. I think we're just arguing about the amount. I disagree that 6 years is necessary under the circumstances, and instead I'm going to ask the court to impose an initial confinement portion of 4 years, possibly with a lengthier portion of extended supervision. I have concerns about the state's reliance on an aggravated factor of Charles's behavior. If this was a case where Charles was 14 and was the mitigated participant and was the one in the car while his father was committing crimes, that would be one thing. But I think we all agree that Charles was actually a more active participant in this crime than Adam was. So it almost feels to me like that argument is asking the court to punish Mr. Evans for prior bad influence on Charles that led him to this day. And honestly, given the statements of all the parties to law enforcement and given what we know about Chantel's phone records and the fact that she was the one attempting to sell various items that were stolen, I think Mr. Evans' version to the PSI author that this whole burglary of the Black and Orange was Chantel's idea because she had a specific grievance against that place due to her sister is plausible. And while yes, it says something about Mr. Evans's skills as a father that he did not step in and say, no, son, you shouldn't do this. I think it was Chantel that was the one that was the brains behind the Black and Orange burglary. And Mr. Evans, well, Adam Evans is the bad parenting in this situation was not saying no, not that Adam Evans specifically led Charles Evans to this conduct. I think Charles Evans at this point is an adult and made his own decision. And in fact, as the person in the bar was the more culpable party. So to then argue that this is an aggravated factor against Adam Evans because he's committing crimes with his son, I don't think he was a bad influence here. I think Charles made his own decision in this case, Judge. So yes, he could have been a better father leading up to it, but I don't think the prior examples of being a bad parent should be treated as an aggravated factor in this particular case. As far as the actual seriousness of the crimes, Judge, while yes, burglary is specifically a serious crime in and of itself, the maximum penalty for burglary for initial confinement is 7.5 years. And simply based on the facts of the case where Adam Evans was the party who was waiting in the car, I think that puts him specifically in a mitigated role in this case, which does not call for an aggravated sentence. I think 4 years is a sufficient penalty for a burglary to a bar where a person has a mitigated role in that burglary as party to a crime. And given Mr. Evans's record, I think that takes it into account. Otherwise, I'd be here asking for probation. Mr. Evans obviously does have a record, but almost all of that was focused on approximately 1 year in 2015, I believe, 2014, 2015. He had a possession of meth charge, he had a bail jumping charge, and he had the federal conspiracy case, which ultimately led to 5 years of prison. But prior to that, he didn't even have a felony record. He had, as the state indicated, some thefts early in his record. He had a disorderly conduct, and then he went to prison. And he got out of prison, and yes, as the state indicated, he did very well in prison. He also did very well on supervision. He had about 4 years there that's described in the PSI where he was sober, he was working, he had his own residence, he had his own vehicle, he had regained full custody of his son, which is very difficult for a man to do, especially with a criminal record. Everything was going fine until things went bad with his significant other. And he left his house, he left his significant other, he left his son, and he went back to using. And now here we are, a burglary charge, the operating a motor vehicle charges. I would just point out, Mr. Evans tells me he wasn't even there when they were stolen, but he did assist Miss Bentley in disposing of them. She was attempting to sell them online. She didn't. And then he helped her take the vehicles to the scrapyard and used his ID to scrap them. They didn't even work, but he put them on a trailer, which involved operating. He knew he didn't have consent. And the meth charge in Buffalo County, which the state didn't say too much about it. I'm not going to say too much about it either. If Buffalo County doesn't consider it that serious, that they just wanted it dismissed and read in with our case, I'd ask the court not to put too much of an aggravating factor on that. But yes, he was in possession of, I believe, about 13 grams of methamphetamine, which is a lot. I asked him why it was all in his vehicle at that time. He said he didn't have anywhere else to live at that time. So all of his possessions were in the vehicle at that time. I believe if the court imposes a prison sentence, the 4 years that I'm asking for, he has significant credit at this point.
What is the credit?
I believe 574 days, not including today. He's been confined consistently since December 11th of 2024. He's been an inmate worker almost that entire time here at the Burnett County Jail. That would still leave enough time that he would be allowed to, and he'd be incentivized to participate in the substance abuse program, which I agree is what's best for Mr. Evans at this time. I don't believe that treatment would be provided in the community, and I think he'd be too tempted in this area to go back to using if he were in Arbor Place or Salvation Army or something like that. But I think if he goes to prison, if he does the substance abuse program and he's released to extended supervision, every indication is that a significant period of sobriety before he's released and released to the structured supervision of extended supervision, I believe he will do just as well as he did last time he was released from prison. He has employment available to him. He's got skills. I submitted a letter from his former employer. He would be happy to have him back. He's got support in the community from his family. Ms. Jensen, who also submitted a letter, has been involved talking to me about his defense, his family, what's going to happen to him when he gets out, treatment that she believes that he needs before he's released from custody. So I do think that when he gets out to extended supervision, that will be an additional structure to him beyond just going to prison where he needs treatment in a confined setting. So given the fact that he successfully completed his federal supervision for 4 years last time, I think if the court were to impose, say, 5 years of extended supervision on this one, there's every indication that Mr. Evans will return to his sober lifestyle and the public will be protected. So I would ask the court to impose a sentence of 4 years of initial confinement, 5 years of extended supervision, and then concurrent time on the operating without owner's consent charges.
Thank you. And for the record, I have read the letter from Mr. Trenter as well as Ms. Jensen's. Mr. Evans, I'm now going to turn to you to see if there's anything you would like the court to know, you want me to know about yourself. Yes.
I'm sorry. I just realized I forgot to mention that during the time that Mr. Evans has been in custody, he has also participated in both substance abuse programming as the relapse prevention program here in the jail and to various programming involving parenting and community relationships, social values, recovery maintenance. He's provided with several certificates that he's obtained in the jail.
All right. Would you like those in the court file?
Yes, please.
All right.
Elizabeth Court.
These are all.
All right, we'll make sure that these are for sure filed. You want them back.
She'll make a copy so she can give you the originals back.
What happens is she'll scan it, put it in the electronic file, and otherwise we throw it away, or I can save them and have them
Get it
sent
back.
back.
I'll take them back.
Okay, so when you're done, okay, so,
Thank you.
oh, do you mind if they're stamped and say?
No, that's fine.
Yeah, just go ahead and stamp it. So then we'll make sure that you get them back, okay?
All right, thank you.
I'm gonna wait until she's done, then I'll go.
And there was also, like, I did do another drug, one, Stop the Chaos, but, well, Burnett County came and got me before I actually received a certificate there. And I was in another parenting class that I was in for about 3 weeks, and an anger management class too, but it was a 6-week thing, and I got taken out of that jail before I could finish
Where
them.
were you housed?
Buffalo County.
Buffalo?
And
Sounds like they have some really good programs.
They do, and they don't offer nothing like that here, you know, but.
Well, we're just starting and getting up with a new jail. We're trying to build more programs. You know, that could be something that you want to focus on, you know, and while you're incarcerated, if you're going to be incarcerated, and, you know, think of some things and try and help this jail out.
I mentioned it because it was all through Zoom and it's all through the University of Madison.
You know what I would like? Maybe you could write down those things and you can give it to your attorney, or you can just send it down through jail mail and then to me, so I have it, because then I can speak with our sheriff and, you know, our jail captain, and I'll look into the programs.
All right, thank you.
Okay. I would appreciate that. So now, Mr. Evans, is there anything you want to tell me about yourself, about your history, about these charges, these convictions, about the victims, about anything that you feel that you want me to know, to correct anything that you heard that was said by the state or by your attorney? You have the floor.
I actually have a lot to say, but
You have time.
so growing up was pretty wild. You know, I watched my parents get robbed at gunpoint for drugs. People in the house getting pistol whipped when I was about 7 to 8. You know, I was standing there crying in the doorway while I was watching this, and I can recall looking on the wall, and my dad had a 22 that didn't work, and I thought about grabbing it and trying to scare him, which I probably would have been shot, you know. But I had enough awareness at that time as a child to know not to do that. But I also had a phone in that bedroom, and I also was aware that there was illegal stuff going on. So I didn't call the cops because I didn't want my parents to get in trouble, you know. There's a lot of trauma from back then, a lot of crazy